Hi, everyone. Welcome to today's webinar. I am Danielle Griffin. I am the Director of Strategic Communications and Initiatives at ONN, as well as the Interim Co-Executive Director. If you're new to ONN and our webinars, welcome. We're the provincial network of for Ontario's 58,000 nonprofits and charities focused on policy, advocacy, and services to strengthen Ontario's nonprofit sector. Before we begin our webinar, I just wanted to go through some frequently asked questions. So if you experience any technical difficulties during the webinar, you can type the issue into the chat box and our team will respond as soon as possible. The webinar is being recorded and you'll receive the recording and the slides in an email over the next couple of weeks, along with some resources. And if you want to ask any questions, you can put that in the Q&A box and we'll take questions towards the end. To ground our webinar today, I want to begin with acknowledging that we are meeting on unceded and unsurrendered land that has been inhabited by Indigenous peoples from time immemorial. The ONN office is located on the traditional territory of the Wendat, the Haudenosaunee, and the Mississaugas of the Credit. This territory is part of the Dish with One Spoon Treaty and is also covered by the Upper Canada Treaties. At ONN, we believe that as nonprofits, we must take seriously our role in responding to the Truth and Reconciliation Commission's 94 calls to action. On a personal level, my family came to this land over time, and I'm grateful to be able to live and work and play here. So today we're really excited to bring you this conversation about emerging trends and risks when it comes to insurance for nonprofits. We're working with our partner, Hub International, who have also brought us an exciting team of experts to join our conversation today. ONN has been working with Hub for several years to provide nonprofits with access to various types of insurance. The ONN team will put into the chat a link where you can get more information about what Hub has to offer. And we're really, really grateful for all that Hub does in this space, and we're really happy to have everyone with us today. So, with that being said, our speakers are Stephanie Dudley, who is the Vice President, Small Business Strategy and Solutions at Hub International, Patrick Cruikshank, Director of Executive and Professional Solutions at Northbridge Insurance, and Jennifer Black, Partner at Zuber and Company, LLP. And with that, I will hand things over to Stephanie.
Thanks so much, Danielle. Really, really appreciate the kind introduction. I'm very excited to be here with everyone today. I recognize how valuable your time is, so we are really grateful for the opportunity. As you said, we've been working together on Hub International with the Ontario Nonprofit Network for many years, over 14 to be exact. So it's a very long-standing and meaningful relationship for us. We currently serve about 25% of ONN's membership, and we work hands-on with each individual member to create and provide insurance solutions that are unique to their specific needs. As everyone on this call knows, not every nonprofit is created equally, so we certainly understand the nuances that are unique to your risk and work hands-on to provide you those coverages, preferred rating, and risk management to suit the needs of your organization. And I'm just going to put up a slide here and let you know. So you can see on the screen that Hub has quite a large footprint in the nonprofit space. We currently serve over 23,000 nonprofit clients. In terms of our organization, we are across North America. In Ontario, we have over 26 offices, or just 26 offices, and we're the fifth largest insurance broker in the world. We organize ourselves in industry segments, and nonprofit is one of the key segments with focus across North America. So again, really excited to be here. Within that nonprofit space, we work very closely with Northbridge Insurance, and they're the insurance company providing the coverage for our clients. And very grateful to be joined by Patrick Cruikshank from Northbridge Insurance, who I've personally known and worked with for many, many years as an expert in this space. As well, we're joined by Jennifer Black from Zuber and Company, who assists with the claims litigation that some of our nonprofit clients experience. So I'm going to keep that short and sweet. And with this, I'm going to hand it over to Patrick, who's going to take it from here.
Great. Thank you very much, Stephanie. Hopefully everyone can hear me okay. Very much appreciate everyone's time as well. I know this is a commitment for everybody to join. So I will try and keep my piece brief so that I can pass the baton over to Jennifer, who I'm sure everyone wants to hear from more so than I. But I have been director at Northbridge now for over 18 years with the company. And I lead a national group that focuses exclusively on D&O, cyber, and professional liability. So today we're really going to sort of focus in on directors and officers and employment practices liability. And I really wanted to cover with your group today, why is it important? What is it? Why is it important? And how it can work alongside other insurance policies like an employment practices policy. We're going to look at market trends, what we're seeing from different sort of claims activities, and I'm going to give some real stories, real claims examples to bring it home and highlight why Northbridge is a trusted partner for this type of insurance. So if we can move the slide forward, please. Great, thank you. So at its core, what is D&O insurance? D&O insurance protects the directors and officers of a nonprofit organization from personal financial losses from alleged wrongful acts. The way I like to look at it is it's a professional liability policy for the management of a company. It functions very similar to that, but coverage does extend to the organization itself. So you can think of it as sort of a two-pronged policy, one that protects the personal interests of the board members, and the second prong that protects the balance sheet of the organization. Financial losses for directors and officers can come in all sorts of shapes, and I'm going to go into sort of what those look like. But it's important to recognize defense costs can be a contributor towards those financial losses, as well as judgments, whether or not the claim holds water or not. Next slide, please. Directors and officers have a lot of tools at their disposal to protect their interests. These can include the company's bylaws, indemnification agreements, and of course, D&O insurance. They work together to create a safety net. Without these protections, many qualified individuals might hesitate to serve on a board because their personal risks could be determined to be too high. D&O insurance is the risk management piece here that ensures that if something does go wrong, the leaders of the organization are not left personally exposed. And why it's important is that directors and officers face a myriad of claims exposures or sources of claims activities. So that can come in the form of lenders or creditors, stakeholders, regulators, so Canada Revenue Agency, for example, as a government source, vendors, suppliers, donors, members, employees, volunteers. As you can see on the list, it's quite extensive. So there's lots of different potential exposures that a board and an organization may face just in the delivery of the services that it provides to the community it serves. So it's really, really important to make sure that the protections that D&Os have are really important and that are there. And I'm going to walk through a couple of claims examples here that can sort of highlight why the insurance is important. So if we can go to the next slide, please. So the first one here is an example of a wrongful termination claim. And I'm not going to go too much into wrongful termination because I know Jen's going to get to those bits a bit later on. But this was a nonprofit organization that does support for individuals with disabilities. And there was a situation where an employee was let go, seeking, amongst other things, accrued wages and vacation pay. And this is an example of a claim that got a little bit complex just because the employee in question was a unionized worker. And so there was a variety of different sort of jurisdictional pieces that were at play here, whether or not the organization had grounds to sue, whether or not they did it correctly. I won't go into too much detail there. You can see some pieces up on the screen, but I think what's really, really important here is that it highlights the importance of a duty to defend policy to ensure that the directors in the organization are protected in the event that any decision made, including an employee being let go, is handled appropriately. And so this is a claim that you can see on the right-hand side of your screen, led to fairly decent ongoing defense costs. And it's important to note that the claimant here in question has disappeared and is not reachable. So while the insured is dealing with this particular claim with the lawyers, not really a good situation that they've been left in. But the important part is that the insurance was there to ensure that they had protection. Next claim. This was another similar employment practices claim. This is a faith-based organization who is alleged to have been discriminatory in their hiring processes as well as the employment processes. And so two individuals who identified as part of the LGBTQ plus community faced some commentary during their interview process, were still hired, but then once they were in employment, they were also subjected to some discriminatory actions, including assignments of out-of-site work, and some comments that were made in terms of the lifestyle choices that they have. All of these things are protected rights that individuals have in Canada, and that the organization is allegedly accused to have overstepped in terms of the conduct that they put these individuals through. Basically, at the end of the day, these two employees stepped away from the work. It wasn't worth the mental anguish and emotional distress that they were going through, and brought a claim for deprivation of employment opportunity as well as constructive dismissal. And it really just highlights, regardless of the quantum of the defense costs here or any potential liability, that organizations really must do all that they can to ensure that they're compliant with laws in Canada or in Ontario specifically, in this case, the Ontario Human Rights Code, and to avoid any internal practices that could be perceived as discriminatory. And so, yes, while it's important that the insurance was there to protect the organization through this process, it also highlighted certain things that the organization needed to reflect upon to ensure that their employment practices, policies going forward didn't put them in a similar situation in the future. Next slide. Another employment practices claim, but this one is for constructive dismissal. And this is one that sort of came at the tail end of the COVID pandemic. And so we had an individual who was in a management position who was dealing with quite a few complications with her employment with the organization, including turnover in her department and return to work sort of issues as well. The employer, doing what they felt was right, tried to accommodate many of the requests of the employee here, including providing work from home options, different compensation structures to support therapy and medication. The end sort of piece here was that they expressed she was a very good employee. They didn't want to lose her, but they still needed to figure out a way to continue with business as usual. The individual declined the accommodations that were offered to her and brought a claim for constructive dismissal. This claim in particular didn't incur a lot of defense costs or any judgments for that matter, but it did highlight the importance of having a really good employment contract, maintaining good records of employment conversations, such as the accommodations that were offered and subsequently not accepted by the employee, amongst other things that I'm sure Jen's going to get to on her slides later on. I wanted to highlight this claim in particular just because of the duration of it. And this one here took over 2 years to get to a point of any settlement. And it's pretty common in some D&O claims and employment practices claims that they can go on for quite some time. And one of the values of the insurance for directors and officers is that it doesn't take those individuals away from their job and the mandate of the organization. The insurance can handle a claim concurrently while those other tasks are still being done, versus if there was no insurance, that might distract them from doing their duties. And next slide, please. Perfect. So this one last here is not an employment practices claim, but this is a claim that sort of touches upon areas of fraud or potential fraud and personal profit by those in a position of power. And I'm reminded, actually, as I was on the train this morning, there was a similar fraud story on the CBC News this morning for a charity that was bringing an action against its former CEO for very similar personal profit allegations. So what happened here was when a new president took over and they were going through, the diligence that they do in that new role, they sort of identified that there was a fourth bank account for the organization that had not been disclosed to the board. And the prior president is alleged to have, over a period of over a decade, been making applications for government grants using this other account to deposit those funds for their own personal use. And obviously that defrauds the organization, puts the organization in a pretty bad spot financially, as well as could conflict with the grants that it's seeking for itself legitimately. This claim, had a fairly significant cost associated with it. Over $200,000 has been incurred to date, and the claim is still open. So it's been open for just over a year now, actually 3 years, pardon me. It highlights a few things. So number one, when they first brought the claim against that former director, it highlighted you can't sue a former director for crime pieces that are covered under a crime policy. So that pushes that onto the D&O policy to cover those fraudulent acts, and triggers our duty to defend, brings into question severability. So the innocent directors, if I can use that term, would still benefit from any protection in the event that they were also named in that type of a claim. Obviously, a bit of a sticky situation, but one that nonprofits or any organization can face, that the policy will provide protection for. Next slide, please. So that gave you a little bit of a taste of the types of claims that you can see. What I wanted to do here was just sort of cover at a very high level what a D&O policy really truly is for. And so at its core, you're going to see 4 sort of main areas of coverage. Number one is the D&O side of a policy. So this is going to cover, you see here on the screen, side A, B, and C. What that means is side A is the personal liability of a director. So in the event that the organization, through its bylaws or indemnification agreements, does not indemnify a director, and typically you will not indemnify a director in the event that they have not acted honestly, in good faith, or in the best interest of the organization, or if the company is financially impaired and cannot afford to do so. And so that part of the insurance comes in at $0, no deductible, and would protect any of the named directors on the statement of claim personally and severably. Side B and C is when I bring in that balance sheet comment that I made earlier. So in the event that the organization does indemnify its directors for any of the wrongful acts that they might face, side B would indemnify the entity for what it has paid to its directors. So this makes the company whole again, and therefore provides that balance sheet protection. And then side C is the entity coverage itself. So in the event that the organization is named in any one of these claims relating back to a wrongful act of a director, the policy does cover the entity on a nonprofit organization. Employment practices liability is another part of our policy. So at Northbridge, this is provided in our policy for all policyholders. It is probably the most frequent source of claim activity for nonprofit organizations in Canada. And I think that's been pretty consistent over my entire career. So it does highlight why this coverage is really, really important. And I think Jen's going to get into a couple of the trends as well in terms of why that importance is increasing in today's world, and really since the introduction of human rights tribunals in Ontario and in other provinces as well. But this would include coverage not just for what I would call employer to employee relations, but also for third parties as well. So organizations or employees of an organization may face allegations of harassment or discrimination by customers or by residents who might use their services. And the last one there on the screen, sort of the third one on the screen, is the fiduciary liability. And so in the event that an organization has a benefit plan for its employees, so think of like a defined contribution plan or a defined benefit plan, employee benefit plan of various different types, this will cover the administrators and the fiduciaries of that plan. And protect them for their liability associated with the management and of that benefit plan. And then side A excess is just an extra piece of coverage for that director and officer liability that I talked to at the beginning of this slide. So in the event that the limits of insurance have been exhausted by the payment of, let's say, employment practices claims or other claims, there's a dedicated limit, 1 million, for non-indemnified losses of those Ds and Os. And this really came into scope a number of years ago. We've sort of, as an industry, have thrown a lot of coverage into a nonprofit D&O policy. And it's all very positive and make sure that the directors and the organization are covered for all the different types of claims that they may see. But we wanted to ensure that we're preserving limits for the original intent and purpose of a D&O policy, which is to protect the personal liability of those D&Os. So that's what that last extension is for. Next slide, please. Sort of what I mentioned just a second ago in terms of all the different things that we've sort of thrown into a policy. I'm going to sort of cover very quickly here what I meant by that. So a D&O policy will cover civil fines and penalties that are levied against a director personally. We will not cover fines against an organization. That's fairly consistent for all insurance D&O in the marketplace. But the Ds and Os, directors and officers of an organization, have statutory liabilities associated with the work that they do. And within those pieces of legislation, there are defined penalties or liabilities that a director may face in the event that they breach any of those particular conditions. So this confirms that the policy will cover those particular fines. It also will cover derivative suits and the investigations associated with those. So the example I gave where the organization or its board sued a former board member or the former president, that's what we would call a derivative claim, where a claim is being made in the name of an organization to seek remedy, to make the organization whole again. So I'm not bringing a claim as Patrick Cruikshank for my own benefit or my harm, but I'm bringing a claim in the name of the organization to make the company, the organization, whole again because of a wrongful act of a director. This extension will also cover investigation costs associated with that suit. So it's a really important piece there to not only ensure that it's there when a claim is made, but it can also ensure that the insurer is included in the process around the investigation, make sure that we're not disadvantaged, and triggers coverage a lot earlier. The next one there is extended coverage for the retired directors. So in a typical D&O policy, they run on what we call a claims made form. And basically what that would mean is that once the policy ends, let's say it's not renewed and it ends today, there's no coverage tomorrow. And there wouldn't be coverage tomorrow even if a claim is made for something that I did today or yesterday. So typically D&O policies will offer like a runoff cover or a discovery period to bridge that and provide future time to make a claim for acts that occurred while the policy was in force. Now, what happens with a director who is retiring is that they don't have a say in board decisions. And that could include the renewal of a D&O policy or continuation of it or the placement of it in general. And so that could put them in a position where they had protection while they were serving. And then when they retire because of decisions of others, they may lose that protection. And so this bridges that. And as soon as their retirement happens, they get an automatic period to protect them for any claims that might be made after they have retired. Typically, that goes for up to 6 years. And then the next one there is reputation management. So this is going to cover costs and expenses associated with a newsworthy event that might cause harm to the organization's brand. And so let's say there was, God forbid, a situation of abuse or a cyber breach, something like that, that was newsworthy enough to get the attention of media outlets, and that potential broadcasting of the situation might warrant that the organization wants a say in that narrative, and not to spin it, but to make sure that they're managing and doing damage control, really. And so this will cover costs associated with public relations to manage that particular crisis or situation. And then the last one is workplace misconduct expenses and business interruption. And so this also goes under another sort of label in the insurance industry called workplace violence. But essentially what it's going to do is it's going to cover counseling costs, including potentially increased security measures associated with a violent event that might occur on the premises. I like storytelling. It is something that resonates with me. So, for me in my career, the one event that sort of triggered this type of coverage was a situation that happened in the GTA a number of years ago where an employee was being let go. And for some reason in the room where that meeting was taking place, they were able to access a pair of scissors and harm a bunch of individuals. that is a violent event that leads to the organization having to, obviously, police presence, people being sent home, potentially having trauma that needs some counseling and other services. But there's a crime scene there. So this is going to cover expenses associated with those employees being sent home and counseling, also the business and income loss that they might feel while they had to shut their doors during that situation. So, it's a way that we can turn what was a negative event to ensure that our insured has not lost any income as a result, or is not disadvantaged by that type of a terrible situation. Next slide, please. So with that, I'm going to pass it over to Jennifer. Jennifer is going to talk to us today about employment practices. And so I will turn my screen off and pass the baton over to you.
Thanks, Patrick. I appreciate the solid lead in as always. And thanks, Stephanie and Hub and ONN for having me. I'm a lawyer in Toronto. I focus a large portion of my practice, more and more, on EPL claims. The purpose of this presentation and kind of where I want to end up is by looking at things that I routinely see in my practice. And I do a large amount of EPL claims, especially in the not-for-profit context. I want to talk about what I routinely see and then kind of the recommendations I have and best practices that you can kind of implement in your day-to-day in your organization. So EPL claims can be difficult to defend. They can be hugely disruptive to an organization. They take a lot of time. They can be very expensive, frankly, to defend. Preparing for discoveries, preparing pleadings, preparing for a hearing can take your valuable employees away from their roles for days at a time, if not more. I work on, as part of my practice, I work on major losses. Think accidents, fatalities, things like that outside of the EPL context. And while EPL claims and those types of claims don't have a ton in common in terms of the potential damages that someone could get awarded at the end of a trial and a lawsuit, they are very similar in terms of the amount of work they require to defend. And they are disproportionately, EPL claims are disproportionately high in terms of usually the amount of documents that are needed to be procured and reviewed and provided to the other side in order to defend a case. So they are surprisingly a lot of work. These are kind of the best practices that I recommend moving forward. So just on this slide, Stephanie, I'm going to talk about generally the types of claims, and then we'll go through some claims examples. And then what I propose is we can talk about some best practices and things that I've seen that I can make recommendations that you can implement in your organizations. So thank you. So the first type of claims that we see through EPL is a civil claim. And a civil claim is what you see when you hear you're going to court. You think a statement of claim, this is the Ontario Superior Court, or it's the Ontario Small Claims Court. There are another claims process is at the Human Rights Tribunal of Ontario. Now, the Human Rights Tribunal is its own specialized tribunal. It's the Social Justice Tribunals of Ontario. There are other tribunals. The Human Rights Tribunal of Ontario deals specifically with claims under the Human Rights Code. And these are typically claims to do with discrimination. They're claims to do with harassment, and they're claims arising out of a discrimination based on disability or a failure to accommodate. The third type of claims that we see that come in are disclosure requests pre-litigation. Often these are, and we see less and less of these, but they're basically a notice letter coming into an organization saying, hey, this thing happened, we're potentially going to sue you. We need to request some documents from you in order to determine whether or not we're going to proceed. And obviously there's a lot of strategy there in terms of what that response is. So that's the third way claims come in. So next slide, Stephanie, thank you. So these are those civil claims that we were speaking about. They usually start by way of notice letter. What happens next is a claim is issued out of the court. It is formally served on the organization. And these are claims that negligence is claimed, which is the failure to do something, intentional acts, which can include physical, mental, or emotional abuse, a breach of duty, a breach of a standard of care, and also with respect to employment type claims, so wrongful dismissal. And Patrick touched on this, but I want to be clear what we talk about when we're talking about wrongful dismissal. Wrongful dismissal isn't dismissing someone in an incorrect way. Wrongful dismissal claims largely arise out of a claim that a person has been improperly compensated following their dismissal. So it's not just relegated to the manner of dismissal. It's usually largely related to the notice period for which and the compensation someone received at the end of their employment. And there are also frequently claims for discrimination tacked on, or claims for constructive dismissal, which are circumstances for which the employee wasn't technically fired, okay? They weren't technically terminated, but they are claiming that the way the employer treated them amounted to a constructive dismissal. And we see more and more and more of these now in this economic climate. The employer is permitted to terminate anyone for any reason, so long as it's not a discriminatory one, so long as they compensate the employee fairly. And so this is the brunt of the claims that we're seeing. They're related to wrongful dismissal. They're related to failure to provide services. They're related to abuse and claims for physical or mental injury against a service provider, for instance. Okay, Stephanie, next slide, please. Claims at the Human Rights Tribunal. So as I said, the Human Rights Tribunal is a special tribunal. Its only focus are claims under the Human Rights Code. So there's our description there. It's a claim, based on a failure to treat someone fairly based on one of those enumerated grounds. And those have to be related to either an employment relationship or a service relationship, and some other relationships that aren't relevant for our purposes here. But the tribunal has exclusive jurisdiction to adjudicate these cases. They can be tacked on to a superior court matter, a civil matter, but the civil court matter has to have another cause of action in addition to a claim under the Human Rights Code. So these claims are unique in the sense that they can be brought by someone who's self-represented. And that's not terribly different from the Superior Court. Someone can be self-represented. In small claims courts, certainly they can be self-represented. But the difference in the Human Rights Code context is there is no opportunity for a party to get their costs. And so what is frustrating and is a shortfall, in my opinion, of the Human Rights Tribunal is that, and this has happened in cases, an individual is upset about something that happened fairly or not, brings a claim, it's served. The organization goes through the work of defending the application. You go through mediation, you go through a case conference, all this documentary disclosure, excuse me, and you end up on the eve of a trial. And the person gets freaked out, doesn't want to go to the hearing, doesn't want to do the work involved with that, and literally just doesn't show up. And there is no penalty for that. And that's problematic because the employer or the organization has gone through the work of retaining counsel or defending it on their own and spending hundreds of hours and spending a good amount of money and time and resources to defend a claim that essentially just went into dust. So from a lawyer perspective, it's a little bit easier sometimes for us to have the leverage of in a civil claim, whereby you are able to recover your costs, at least in theory, if you win a case and the plaintiff loses in the human rights tribunal situation. It's just not a possibility, and that is something that has a massive impact on organizations who have to pay to defend these cases themselves. And so that process at the Human Rights Tribunal looks a little bit different. It's a little bit less formal. It's still a court of competent jurisdiction. They still have the right to make orders. They have the right to award damages, and they do get it right. It is a overburdened tribunal right now. They're running very behind. Likewise, the Superior Court is also running behind. So access to timely justice in either of those forums is a bit of a challenge, certainly right now. And, to Patrick's point, we see claims at the Human Rights Tribunal go on easily for 2 years, no problem. We also see claims in the civil context go on likewise for years. And this is just, the nature of the beast in terms of the procedural steps, and as well as getting access to court time, frankly. So they take a lot of time. All right, next one, Stephanie. Thank you. So talked about this briefly. Sometimes an organization will get a demand for documents. This is not government. There's no freedom of information request that can be made. What they can do is they can write a letter and say, we want the service records from, X till Y for this person. They could also bring an application to the court to get something which is called a Norwich order, and essentially the court orders production of documents. It really depends on the situation in terms of what the strategy is on whether to produce documents, what to produce, and how to deal with that. And I encourage you, if you find yourself in this situation with a demand for documents, you probably aren't surprised when you get this letter. Something's probably already happened, but that you do consult with a lawyer in terms of what your options are, and come up with an effective strategy, because you can sometimes, steer these off before they get going. Next slide, please. So I thought by way of exercise, we could go through a sample civil claim. So this would be a claim that would have been issued in the Superior Court. This was a case that I had. It was a disabled person supported in an organization's day program. And so the claim comes in, it's for $1 million. The allegations, of course, are that by the disabled person, the client's mother says that the agency support workers failed to provide proper care, and actually that her child was abused. And a wrinkle in this is that the client was still within the agency's care in their program. So the claim comes to me. By the time it comes to me, we're talking about allegations of things that have happened 3 years in the past. And the records in terms of who was working with the person at the particular time that we were interested in, all of those workers were gone. All of the support workers were gone. They no longer worked with the agency, just for whatever reason, nothing nefarious. They had just moved on to new opportunities. And so the next step is, okay, let's look at the records and see what there is. And there were no notes in terms of any investigations being done, in terms of any of the complaints back when when these events alleged to have actually happened. And so didn't have a lot of documents to work with in terms of substantiating, whether these things happened or whether they didn't happen. And so the next thing that we look at, absent, direct evidence and talking to the people involved, is, what are the policies on these things? And so, pull up the policies. What were the policies at the time? Okay, get access to them. What was the training on those policies? Were the staff trained when they were onboarded? Were they trained on a yearly basis? Were there logs, indicating and sign off sheets that they had done this training? Were the policy documents that were in place at the time, were those retained? What did those say, historically, way back when? And, we were able to pull those. We were able to show that the relevant people, they were trained, they had done the training. We had documents, ensuring that was the case. We had copies of the policies. So, this goes to keeping proper records. Keep those old policies as you update them, save them in a folder with the year that they were implemented, get sign-off sheets, keep them all together, keep them in the employment file. And if there is an event that happens for which your duty to investigate is triggered, keep good records, ask the questions, even if you think it's unfounded. Do the interview, ask the 5 Ws, and get the pen to paper, get a statement from the person and keep it in the file. Because we can find, Jane Doe 6 years after the loss and ask her what happened, but she's not going to remember. And if she says she remembers, that's also prone to scrutiny. So a document that's created temporally when a complaint is initially made, regardless of its veracity, is going to be worth a lot more than what someone says years and years after a loss. So good investigations, keep records, have a records retention policy, and keep your training logs in terms of what was done and copies of those policies. Thank you. So the next example here is an human rights code claim that we had recently. This involved an older employee of an organization. It was a congregate care setting, and she was injured at work. There was no WSIB. And she had injured herself at work. She took some time off from work. And then her doctor provided a medical note saying, she can come back to work, but it would be in a job, that wasn't akin to the job that she had prior to getting injured. She can come back and she can, work on the computer doing data entry or something from home. The job didn't look like, the job that she was hired to do. And so the organization looked at it, but the immediate response was, well, we don't have any work from home jobs, nor do we have any data entry jobs. We don't have a job for you. The employee goes to the Human Rights Tribunal, claims constructive dismissal. So this is not in the case where the employer has let her go, but she says the employer failed to accommodate me, and by not offering me work that I can do, failing to accommodate me both in terms of my procedural and substantive rights of accommodation. And she sought $30,000 in general damages and full lost wages. And this is not in the wrongful dismissal context where you hear, weeks or years per year of service, any of that. She was seeking full lost wages from the date she said, that her doctor said, that she could return to work up until whenever, up until the hearing. And so every day the clock was ticking on the value of the damages of that claim. And so again, get involved in this claim. What are your policies? What sort of an investigation was done? What was the conversation in terms of the procedural duty to accommodate by HR staff with this individual, and what went on there? And so again, these are expensive claims. They take a long time to adjudicate. And here in this case, this was a self-represented person. We went to a mediation, and the adjudicator at the tribunal tried to explain to her, some problems with her case. that didn't appease the applicant. She wasn't happy with that, and she continues on, and we continue on to a hearing. And so these ones, they take time, they take nuance, and they take a lot of involvement between the employer organization and legal counsel in terms of defending them. All right, next slide, please. So generally speaking, how can we set ourselves up to avoid claims, or for the claims that we can't avoid? Because in my view, it's only a matter of time. The changing, economy, society is changing. We're seeing more and more of these claims. And I think if you've been lucky enough to not have one of these yet, it's only a matter of time. So, basically, as a starting position, have your HR staff in charge of policies, updating those policies all the time. Are the policies available to staff at all times? I know some organizations have intranets for where the policies are available online for staff. No one's really doing binders anymore, fine. But don't just, have the policy at the onboarding meeting and have the person sign off and then they don't have access to it again. Because that's one of the things that comes up frequently in discoveries and hearings is, did the employee or the client have access to the policies at all times such that they can consult them to inform themselves? Because of course the position on behalf of the organization is always going to be, she or he agreed to abide by the policy, and that was an important part of their employment or an important part of our service agreement. Update those policies, keep copies of the old ones, and get them signed off. Get them signed off. Again, training the same sort of thing. Do this yearly, refreshers. I think that's a really valuable thing. I have cases where, you've got a 15-year employee who at onboarding did training on a particular policy, and I don't think you can fault them for not recalling exactly what the terms of that policy 15 years later. Retaining records. Most organizations are digital now. I know it's been a challenge for a lot of organizations to move from paper records to digital. I have plenty of cases where we actually can't access the paper file. Files are corrupted. No one knows where they went. Try to avoid that to the extent that you can possible, because absent people remembering, documents are going to be your best sort of case. As a lawyer, coming into a case and trying to defend an organization without documents is, like trying to get in a fist fight with your hands tied behind your back. If you find yourself in the situation, whether it's something triggered by the Occupational Health and Safety Act, a complaint, that runs afoul of one of your policies for harassment, discrimination, something like that, conduct an investigation in a timely manner. It doesn't have to be fancy, okay? Just get, the who, what, when, where, why, how, talk to everyone that had anything to do with it, get a statement from them, get them to sign it. And then there's going to be situations where it's a high risk situation, and you might want to consult with an external investigator, and it might be the case that you hire a lawyer to do that. And there are certain benefits to having a lawyer do an investigation as compared to, your HR team or an external investigator who's not a lawyer. But again, this is just depends on the risk in the situation. So, and again, I can't overstate this enough with respect to investigations and policies. At the HRTO, when you're filling out your response to an application as a responding party, before they ask for any evidence of the incident for which the applicant is claiming, they actually ask to see copies of policies and copies of documents with respect to investigation. So they want to see that you're organized, before they want to see anything to do with the facts. And I think that really, really, really speaks volumes. Um, just with respect to employment contracts, the law has changed massively in terms of termination clauses in Ontario. If you have not updated your employment contracts in the last couple of years, I cannot urge you enough to get legal advice on that. If you are an agency or an organization that utilizes fixed term contracts, please seek legal advice on that as soon as possible to make sure your contracts are good, because they really attract massive risk and massive financial liabilities if they're not done right. And more and more I'm seeing those. They're coming in. They're hard to get right. They're highly specialized. They are not something that a non-lawyer, in my experience, can draft successfully. In terms of trends, again, with the economy, we're seeing, more and more employment types of claims. Businesses, organizations are allowed to lay off, and they're laying off because of changing business needs. But these are the situations that are lightning rods for wrongful dismissal cases. I mean, you can't go in your car, listen to the radio without hearing the lawyer saying, "Call me, we'll get you the compensation you deserve." And one thing that's of note is that not-for-profits, in terms of the law, are not treated any differently than any other sort of major corporation. So just because you're a not-for-profit, and you have public funding coming in, you're doing fundraising, any of that, you are not treated any differently than, say, Microsoft. So please keep that in mind, and seek legal advice in situations for which you're going to lay someone off, you're firing someone for cause, or you need to update your employment contracts. The court can award damages on top of notice periods if you don't pay an employee correctly upon termination. Lastly, update your policies. There's policies coming in 2026 with respect to hiring and job ads and the use of AI. And so, keep these things in mind. Have a point person that's keeping you abreast of the changing policies, updating your own internal policies. You can't go wrong by doing that. And social media, as part of these settlements that we do get to in these cases that I handle, we always include confidentiality provisions, including provisions for which, a party can't go on after the case and make a negative Google review or go on social media or anything like that. And including, taking those down. If anyone's ever navigated like a Google bombing review situation, they're no fun to deal with. And so that's something that, is a lawyer can guide you with in terms of getting to a successful settlement. So those are my comments. I know we want to leave some time for questions. I hope that was helpful. And thank you.
Thank you so much, Patrick and Jennifer and Stephanie. That was great. We do have a few questions. I hope we can get to the few that we've received. I will sort of go in the order that we received them. So the first one is, if a not-for-profit corporation has not completed filings to the Ontario Business Registry for several years, and as a result, some of the directors on the OBR are no longer on the board, and some of the current directors are not on the OBR, who is covered by the D&O liability insurance policy?
Sure, I'll take that one.
Thanks,
And maybe
Thanks.
before I start with the answer, I just want to sort of expand on something that Jen was saying in her final comments around, the court's not treating directors of a nonprofit organization differently than a publicly traded organization. That's not confined to employment practices liability. That would extend to all director liability. So any alleged breach of duty or breach of responsibility, the courts hold all directors of all organizations to the same standard, pardon me. So I think it's really important just to highlight that. on a D&O policy, they're structured or written in a way that's quite broad. So the language that you would see on a definition for a director and officer would be all past, present, and future directors and officers of that organization. Now, the insured persons under the policy will not be limited to the D's and O's. It will also extend to committee members, treasurers, trustees, employees, volunteers for nonprofits as well. So it's quite broad in terms of who is protected under that policy. But it's important to note that in the event that that claim alleges a wrongful act of a prior director, as long as that insurance policy is still in scope, the policy should still protect that past director as well as any of the current directors that are on that board.
Great, thank you. So our next question is D&O and EPLI insurance seems to be the main coverages that an NFP might need, so not for profit. The environment is changing and people are working remotely, increasing the risks. What other types of coverages are being strongly recommended to clients aside from these main two?
I'll take that one again as well, I think. Feel free to jump in though, Stephanie. I'm sure you've got something to add.
I wonder if we're going to say the same thing right now. I'll let you go first.
You want me to go first? Okay. So I think one of the examples that Jen touched on sort of treads the line between D&O insurance policy and an abuse insurance policy. And so depending on the nature of the organization and whether or not they're dealing with any vulnerable persons, and that can be due to age, disability, et cetera. So think about schools, long-term care, anything in the middle. It's very, very important for them to ensure that they have an abuse insurance policy as well. And that will make sure that there aren't any gaps between all the other insurance policies that an organization may buy. And then the one for me that I think I've been involved in the most over the last number of years is cyber, and the remote work in that question sort of struck that chord for me. So as organizations and as the world sort of becomes a lot more dependent upon technology, remote work, remote tools, like all the different applications we might use on the cloud, organizations have an exposure to privacy and network security liabilities. And it's also important to note that a D&O insurance policy covers third-party liability. And cyber brings crime and first-party exposure. So think about just operational disruptions and the associated business loss that might bring as well. So a cyber policy is much more comprehensive to that particular need. Steph?
Yeah, just to expand on that a little bit, particularly with abuse, often like it is very difficult to purchase a standalone abuse, and it would go hand in hand with a commercial general liability policy. But the general liability policy, so essentially, protecting you and your organization for property damage or bodily injury, even if you are working at home, could come into play because there are extensions, for, libel and slander, things such as that. Another thing, extension from a CGL policy that you might be looking for is non-owned auto coverage, because often, even though you're working from home, you may be asked to use your personal vehicle to go run an errand for business, whether it's to go to the bank or drop off a check or drop something off at a client. So you could gain protection for it that way. Certainly the cyber, Patrick, top of mind for us too. I know a lot of our clients through the program are wanting to learn more about it, understanding more, and we're seeing more and more claims come in that scope. So those would be some of the key coverages we would recommend as brokers for our nonprofit clients.
Thank you. And I think we have time for the last question that we've received, and it is, do volunteers sign off on certain policies or just staff and clients?
So volunteers are not employees. So there's a distinction there. However, from a legal perspective, there's no downside to having volunteer sign policies. So as long as they're applicable to the work that the person is performing, the interaction that they're having with clients, privacy policy, confidentiality policy, all code of conduct. Absolutely, you are vicariously responsible for those volunteers who are, not providing services for compensation, but providing services on behalf of the organization. So 1,000% yes.
Wonderful. Well, that is it. We got all the questions and we ended exactly on time. So thank you everyone for your time, for being with us today. Stay tuned for the email with all the resources and the webinar recording. And thank you again to our panelists.
Thank you.
Thank you very
Thank you
much.
so much for having us.
Thank you.
Appreciate it. Have a good day.
Take care, everyone.